Good afternoon, Anthony and Tara. Today I wanted to meet with you to discuss some estate cash and some expenses as well that we can see in the estate process. So first, we're going to take a look at the cash requirements of an estate for Anthony, and we want to go ahead and look at this so that we are prepared to cover any expenses that we may not be planning for currently. So as we can see here on this chart, your estate cash needs are, so first we have $3,500 for a last illness expense in the event that you would need to take an ambulance somewhere, or say you are in a hospital before death. And this includes the stop loss on your insurance. We also have in this funeral expenses, as well as the payment for your credit card bills and the note that you currently have. This sheet also does take into account taxes. So for estate fiduciary income taxes, we can take into consideration that there's typically 9 months between death and the estate closing. So we need to cover the cost of probate assets for those 9 months, as they will generate income tax through that time. And let's see here. We also include within this the state estate tax that varies depending on the state that you live in. And we also see property taxes on here as well. I've also included some funds for Edmund here, and a business operating fund for 6 months of salary to all employees, 9 months of a family allowance, education for the kids, as well as some disability costs. And with that, we can look to actually eliminate a family allowance, education for the kids, and we do need to look at the disability insurance here. So we're going to assume with the disability insurance that Tara would need $50,000 to live on, and with your insurance, her maximum cash reserve option would be $35,000. Now going back to the family allowance and the education, we can eliminate that family allowance if we do sell the business, and we can use that sale of the business in order to fund the family in the event that Anthony, you were to pass away unexpectedly here, or even at the end of life, I guess, just looking at the cost of your estate here. And then education, we can actually fund those education expenses early for all of the kids. I know you talked about wanting to put some money away for Danielle to get through all of her education, and then also helping out your other kids with their education expenses. So we can look at ways to fund that in another meeting, but for now, let's kind of just keep that in the back of our minds. Now, after we add up all those expenses, your total estate cash requirements comes out to $1,474,306.50. Now we're going to move on to administrative costs at the time of that estate being closed. And an estimate that I came up with for the administrative expenses is $85,000 to pay for, any attorney fees or court fees, and there's some other miscellaneous expenses in there that we need to take into consideration. Now we can reduce this using will substitutes. We can reduce hard value assets, we can reduce potential litigation, and we can reduce attorney fees. The larger items to focus on here, though, are reducing hard to value assets by moving them to the estate, and reducing attorney fees by ensuring that they do not charge based on the size of the estate. So with reducing hard to value assets, we could take the house and the Benson Animal Care Center, as they would require higher fees to get a valuation, and with that we can move those into the estate. All right, now next we are going to look at some liquidity sources. So we can see on the sheet that there are several different sources of liquidity that you currently have that include cash and cash equivalents, such as your money market account or your mutual funds. And then we also have life insurance, stock as well. We have the AATB Family Limited Partnership. And this all just kind of comes together here, and your total estate liquidity is $4,172,200. All right, now we're going to move on to improving estate liquidity and ways that we can do that. So all of the options below are possible for you, but the most notable that we should bring up here are: one, lowering administrative costs, which we already discussed. Another one is reducing the gross estate by qualifying for the estate tax marital deduction and avoiding the necessity to pay family allowance by having adequate life insurance. With that, we can also look at ways to increase cash availability for the estate. And this is the same thing as the last sheet here. All of these are feasible options for you, but some of the key areas to note here are to first increase the assets as you age. And to do this, we would switch your investment portfolio to a lower risk since you are currently at a moderate risk. So we could look at moving you down to more of a conservative moderate, or all the way down to conservative even. But another important one here is to maintain value of interest in the event of death by entering into a buy-sell agreement with other owners. And, as we kind of look at ways to sell the business, we can look at how that buy-sell agreement could benefit you, Anthony, and your family as well. All right, and one last sheet here that we want to take a look at is with Tara. So Tara, we wanted to discuss a what if scenario. If Marlene were to die, her will does leave everything to you, but let's say you don't want that money. So what this would be called is a qualified disclaimer, and there are some requirements within that. So first, the disclaimer must be an irrevocable and unqualified refusal to accept the interest. The second, the disclaimant, or the person making the disclaimer, which would be you, Tara, must not have previously accepted or enjoyed any interest in the benefits from the property. So if you have already accepted in writing that you want to take on these assets from Marlene, then we really can't go back from that. Now, just like I said, another requirement would be that the disclaimer must be in writing. And then lastly, the disclaimer must be received by the decedent's estate within 9 months after the later of the date on which the transfer creating the interest was made, or the day on which the person disclaiming the interest reaches age 21, which we don't have to worry about that. But in the case of property held at joint tenants with rights of survivorship, a surviving joint tenant generally must make the disclaimer within 9 months after the decedent's date of death. Now, that was a lot that we covered right there, but I really hope that you guys found this information informative. And as always, if you have any questions, I would love to answer them for you right now or any time down the road. So thanks, guys. Have a great rest of your day.